Hello and welcome to today's podcast. My name is Alex Meniotis from LexisNexis, and I'm joined by Tim Hill and Claire Watson, who are from Eversheds Sutherland, to understand more about fire safety and insights into typical questions they're asked as lawyers on compliance, pitfalls, and enforcement. Let's kick things off with the both of you. Tim, Claire, tell us a little bit about why you're the right people to discuss this today. Tim.
Thanks, Alex. Eversheds Sutherland has a really significant health and safety practice. We advise corporates across a multitude of compliance topics, both in the UK and globally. Fire safety is one of my particular specialisms. I've dealt with a lot of incidents involving either fires themselves or issues where fire authorities have felt that the precautions in place in buildings have not been good enough and have therefore brought some sort of enforcement or prosecution actions. Increasingly as well as advising on the regulatory reform fire safety order, which is the key piece of legislation. I also do a lot of building safety and construction design and management work as well.
Hi Alex. So recently we're seeing questions from clients in relation to the Building Safety Act and the reforms to the regulatory reform fire safety order. We've considered the duties of the responsible persons and other duty holders under the fire safety order, examining the practical impact and the recent changes they have.
So just touching on that, Claire, with risk assessments, what is the actual duty?
Thanks, Alex. The risk assessment has to be suitable and sufficient to identify the general precautions and reviewed A, periodically, and B, when there has been a material change. We often get asked about what this means in practice, and a material change is simpler to understand and could include a layout change or installation of a new fire alarm. Periodic review is more of an intangible concept, so it could be 6 months, a year, or even 3 years, and will depend on the type and risk profile of a building.
So, Tim, who would need to produce a risk assessment?
Under the fire safety order, that's the responsible person, and that's a defined term which is deliberately quite broad. So that can include both the employer in a corporate organisation or the person in control of the premises. So, for example, in multi-occupancy commercial premises, the landlord would typically be expected to produce a risk assessment for the common parts, the bits that everybody uses, the entranceways, car parks, fire escapes, etc. But then the other occupiers would do their own risk assessment for their demise, their part of the building. As you can imagine, that does often lead to challenges where one responsible person might need details from the other so that they can check that any implications from, say, the landlord's area, has that got an impact on their part of the building, and vice versa. Sometimes that's not directly covered by the order, so you might have to rely on leases or contractual documentation, and that can create the practical issues of how are you sure you've got the right information. It's a reasonable request, though, if somebody goes from their, if they're a tenant and they go to their landlord for more information, so it'd be quite difficult to object to that. There is a broad duty to cooperate, coordinate amongst people who share a common interest. So working together is really key. Having good communication with all the parties in a building is what this is supposed to be in place for. And we see that mirrored as well in broader building safety, particularly post sort of Grenfell fire disaster. A lot of the challenges have been around making sure everyone's talking to each other and communicating well.
So just keeping on the theme of risk assessments, Claire, can I ask, can anyone prepare a risk assessment? What's your point of view there?
In theory, an employee can, who has sufficient competency and capacity, or it can be prepared by an external consultant. So the responsible person has a duty to make sure that a suitable and sufficient risk assessment has been completed. For complex buildings, it might be necessary to appoint a specialist fire safety engineer, especially when the changes made by the Fire Safety Act 2021, which expands the remit of the application of the fire safety order to apply to the external parts, such as the balconies and cladding, etc. And it clarifies that such external walls, flat entrance doors and structures of buildings must be accounted for in the fire risk assessments. So if appointing an external consultant, proper due diligence on their qualifications, skills and experience is fundamental. because if not, the organisation is at risk.
So what would be some of the common issues that you see clients facing? And I might throw that to you, Tim.
I mean, these are quite nuanced for a lot of clients, but a lot of them are around, as I've said already, the split between who owns which part of the building. There are also issues around demonstrating competence, and that's an increasing focus. Again, sadly, after too many incidents where there have been question marks looking back as to whether the person who has assessed the building is genuinely competent to do that. We've certainly spoken to some fire experts who have raised some concerns that you might get, for example, retired fire safety officers who have general fire experience, but not necessarily looking at buildings. So you've got to be really clear that the person you're appointing to do your risk assessments is genuinely competent, and that you've got the evidence to support that if you're ever challenged. Don't just assume because somebody holds themselves out as a fire safety consultant, they have the right skill set and the right qualifications to do that. So that's certainly one area in terms of who does the assessment. One of the other key areas, though, which clients repeatedly fall down on is they do their risk assessment, they get a remedial action plan, and then they fail to follow that through. So they've effectively identified issues that need looking at, but then by not completing them, you're giving, it's almost an open goal for a regulator to say, well, having identified this, why haven't you fixed it? And so that ability to make sure things are tracked and closed out might sound very obvious, but time and again, that is a core part of what we see. And the final one is that in a lot of cases, risk assessments were done a long time ago. And while there isn't a specific time limit that you must update them, you have to keep them up to date, or if there are any significant changes to the building or the layout of the building. And that again is sometimes overlooked. So we're often presented with risk assessments that might be 10 years or more out of date. And even if things haven't massively changed, that doesn't look great if there's ever an issue in terms of whether you've gone back and properly looked at this, as opposed to just getting a document that ticks a box to say you've completed it.
So I'm just going to touch on a point here. You mentioned about assessing your recommendation and changing it as and when is needed. Is there a best practice time frame as to when to do it? So obviously 10 years ago you've done it. That's probably too long between looking at assessments. So is there a best practice in terms of the time frame of assessing your assessments?
It's a good question. There's not a hard and fast rule, and partly it will depend on the level of risk in your building. So if, for example, you've got a building with restaurant facilities downstairs that might create an increased fire hazard, you perhaps want to be doing that on an annual basis. If, on the other hand, you've got a fairly inert building which doesn't have any enhanced risks, every couple of years might be fine. So the whole basis of risk assessment in general, not just for fire safety, is you've got to take responsibility for deciding what's the level of risk for my building, for my operations, for the things that we do, and then responding accordingly. And in practice, I can rarely think of any criticisms that people have made a conscious decision to do it every X years, and that's been criticised. It's more that they say they're going to do it every 3 years and then they don't. And then suddenly it's 5 years, 6 years, and they haven't done what they said they were going to do. So people let themselves down by sometimes being over ambitious and saying, right, well, we'll do it every year. Maybe you don't need to. Maybe it's better to do a proper review every second or third year rather than a slightly tick box exercise every year just to say you've done it.
Okay, that practical and absolutely makes sense. I just want to shift the conversation more towards, I guess, enforcement and in terms of enforcement. So, Claire, I might ask you, who is the enforcing authority and what powers do they have in this world?
The enforcing authority is the local fire and rescue service. So in terms of powers, these are wide-ranging and they range from serving an enforcement notice to ultimately a prosecution. And such enforcement action is public. It has commercial, reputational and legal consequences. Fire inspectors, for instance, have the power to enter premises, inspect documents and preserve a scene.
And would you expect a local fire and rescue service to take enforcement action for not having a risk assessment that is suitable and sufficient or at all?
It's certainly a very common allegation, and certainly the main part of a fire safety management system is having that risk assessment and having it up to date and relevant to your premises. So that is one of the key things that, for whatever reason, if a fire and rescue authority comes round, and that could be because they've had actual concerns, there's been some sort of incident or alarm. It could be whistleblowers, it could be concerned tenants who think the landlord's not doing enough. There's a whole host of reasons why they might come, but they will ask straight away for your fire risk assessment. And if that's not there, or it is there, but it's not good enough, or it's very out of date, that is certainly the first trigger for an enforcement notice. In general, we do find that fire and rescue authorities are reasonable in the sense that they have what should be a common purpose: to keep people safe, to minimize the chances of fire. So if you're not doing the basics, you can expect to have enforcement action against you. Generally, though, they will give you a chance in the sense of a notice first, rather than rushing to prosecution. But we still do see companies who get a notice, think, all right, okay, great, we're not being prosecuted. But then back to what I said earlier, they don't then actually carry through and track the actions and close them out. So surprise, surprise, when the fire and rescue authority comes back in a month's time to see if you've done everything, if you haven't, that's when things will get really serious. So people will be given a chance to work things out, and they need to be looking at all of their systems and processes, fire alarms, emergency exits, fire doors, all the things that would be inspected, would be expected to be maintained, keeping them in good order, keeping them free so that exits aren't blocked or obstructed. These should be regarded as basics, and yet all too often that is what comes through in enforcement notices or prosecutions.
And just to note here as well that it is possible for risk assessors to be held account personally for holding themselves as experts when they are not, or if they produce a substandard risk assessment.
Sorry, Alex, I think you've gone on mute.
That's really interesting. Thank you for sharing that, Claire. And so what are the sanctions if someone is prosecuted for a breach?
There's an interesting legal angle as regards to sanctions, because the health and safety sentencing guideline, which we've now had in place for just over 8 years, doesn't formally apply to fire safety regulations, because the Regulatory Reform Fire Safety Order doesn't directly link to the 1974 Health and Safety at Work Act. In practice, though, fines can be very large, and there's certainly been cases I've been involved with where, even though they don't strictly apply, judges will often look at the health and safety sentencing guideline as a bit of a benchmark, and certainly that approach of deciding how far below the standard that's to be expected have you fallen. The harm risk is always going to be the highest level of harm because of the clear dangers of fire. And then they will look at the size of the organisation. So they're able to use normal criminal law sentencing principles, look at the guideline, even though it doesn't technically apply, and then decide in the round if a fine is proportionate to the size, means, culpability of that defendant. I think Claire touched on this earlier. The reputational and commercial damage is almost the bigger impact that we're seeing now, particularly for larger corporate clients. All of these cases are disclosable. They can be very high profile. It does cause significant issues, because you will clearly, particularly if you are a landlord or a building owner, if it's found that you're not looking after fire safety, that will just ruin your reputation across the board, and you'll find it very difficult to get tenants, difficult to sell the building, difficult to get mortgages on properties within the building. So it has a lot of wide-reaching commercial implications as well.
As an example, if we just look at a relatively recent case, so the highest fine for fire safety breaches to date is Bupa. And this was a risk assessment where the smoking risk assessment prepared for a resident did not assess his use of emollient creams, which contain paraffin and can be flammable. So the resident sadly died following a fire incident where the clothes had become flammable from the emollient creams and were set alight whilst he was smoking. And the fine in that case was £937,500, plus another £104,000 for the prosecution costs.
It's a terribly, I guess, sad incident, and there's been many, I guess, high-profile sad incidences that we can review and assess. The Grenfell Tower incident was harrowing and one of the largest, or certainly, if not the largest, profile fire in recent times. How has that shaped the current regime?
It's had an enormous impact on the regime around both fire safety and building safety more generally, because the two are very closely interlinked. There have been some more minor changes to the fire safety legislation, expanding the remit of the fire reform safety order, and also clarifying the competence of individuals able to do those assessments. In respect of risk assessments in particular, the Fire Safety Act 2021 requires the responsible person to now record all the findings that they come across, not just material findings, which is how it used to be. And there's also been a removal of the number of employees that would trigger these. So it used to be just for larger companies with more employees, but that's now been removed. So it applies to a much broader range of organisations who have to now complete risk assessments and make sure they have these in place. And I think more fundamentally, the Building Safety Act has pushed this concept of the golden thread, which in essence is saying you need to be responsible as a building owner to know exactly what has gone into your building. So all the materials, the building techniques, the layout, the as built rather than as designed. You need to be able to point to who have been the appropriate competent people who've designed and signed off the building, so that you've got a very robust set of documents and files and health and safety information about all aspects of that building, with a particular focus on fire safety. But that could be just as applicable to for example, the recent rack scandal around the sort of concrete that was not good enough. Again, you would be expected in future to know exactly what your buildings are made of. If they've got a lifespan, what do you do at the end of that? And so making people more accountable for the buildings they own and operate is a much broader theme, including fire safety, but way beyond that as well.
So as we close today's podcast, Tim, Claire, thank you so much for your time. I just wanted to ask whether you had any final remarks, and I might start with you, Claire.
So to reiterate one of the points that we made earlier on, just looking when appointing an external risk assessor to make sure that you're checking their competencies. So check not only their qualifications, but also their past experiences. For example, if the building that they're assessing is a high-risk residential building, has the fire risk assessor completed risk assessments of this type of building previously, or has their focus, for example, been on retail shops? Tim, is there anything further you'd like to add?
Yeah, I think the main issue for me when I think about advising clients in this area, one of the key focuses of the Building Safety Act in particular is to have increased transparency around ownership and operation of buildings. And also one of the requirements on building owners is not just the traditional definition of competency, so skills, knowledge and experience, but also now includes behaviours. So actually looking at the behaviour of landlords and owners is really key. And what we're starting to see is that many large property owning clients who have huge portfolios of all different sorts of buildings, often owned in quite complicated corporate structures. This isn't about getting behind the company structures. It's not about piercing the corporate veil directly, but ultimately, if your name's above the door, you can expect to be held to account a lot more now. And even if that isn't directly legally, certainly in terms of public inquiries, public opinion and media will focus on what ownership models are doing. And that ties directly into a broader theme around ESG and corporate responsibility, particularly the S bit of the ESG. So social, community, looking after the people, both that you employ, but also that are your tenants or customers. So I think there is a greater expectation that you can't just be sort of a hands-off distant landlord. You need to have greater governance and oversight of your portfolio, of the third-party managing agents looking after things for you, understanding what's going into your buildings, and even for existing buildings, spending the time to do a bit of background digging to gather as much information as you can, so that you are proactively looking at this and not just responding if and when there's a problem.
Thank you. That was both very, very insightful final remarks. Thank you. And thank you so much for sharing your insights. I'm certain our listeners will get tremendous value from this podcast, and we're looking forward to doing it again soon. Thank you so much.
Thanks, Alex.
Thank you.